Hello everyone, welcome to the second episode of our new series on privacy enhancing technologies. Today we are extremely honored to host our speaker, Professor Kobbi from Georgetown University. Professor Nissim will present to us a methodology towards reconciling computer science and legal approaches to privacy. Myself, as a grad student working in differential privacy, I'm more than excited to have one of the pioneers here with us today. Following the presentation, Andrew Trask will moderate a Q&A session. Professor Nissim, it's a pleasure to have you here with us today. You have the virtual floor.
Okay, thank you so much for inviting me and for the kind introduction. I'll present work in progress about the methodology for reconciling computer science and legal approaches to privacy. I have a few disclaimers. First, it will not be a complete methodology. I don't know if one exists, but I'll talk about elements of such a methodology. And the second thing I'll say is that although I will mention and we'll see text from the law and we'll analyze some of it, I'm not a lawyer. This is not legal advice. This is research done by mostly computer scientists with collaboration with legal scholars. Okay, so let's begin. I guess I don't have to convince this audience that we have a fast-growing number of decisions of legal consequence that are made in computer systems. These are a few examples, like credit score that has been with us for many years, but also some new applications. And there are tons of benefits for society, but also this brings risks to some essential societal value, like privacy, discrimination, concentration of power, misinformation, and so on. In this talk, I'm going to focus on privacy. You could say, oh, we prepared, we worked for a few decades, we have some new laws and regulations, in particular the GDPR in the EU, but also some regulation that is emerging in the US and other parts of the world. And we also developed theory and practice of strong privacy-enhancing technologies. We use encryption all the time. We're beginning to use secure multi-party computation, to use differential privacy, blockchain technology, and so on. But I would say that there is a rift between these two worlds, and they speak different languages. The concepts may sound the same. We're using the same words for the concepts, but they are different in content. We argue differently. We even follow different and sometimes conflicting values. So it's not clear how these two things work together and how they map to each other. So here are a few questions. First, do the systems that we use comply with our social norms, in particular in the way that they are expressed in law? And on one hand, they must, because it's the law, but on the other hand, it's not clear exactly what the law requires. Translating the law into technical language, there are a lot of problems there. And because of the huge number of decisions that are made in computer systems, even if only a small fraction of those would need human review in form of a judicial system or administrative system, then that would quickly overwhelm these systems. So to me, this means that we need to do things right when we're doing them on computers. But the question is whether we understand what we need to do. Another issue is that some of the regulatory requirements are not really in agreement with our up-to-date scientific, technical, mathematical understanding of privacy. And this really needs to be corrected. Otherwise, we'll have gaps between what is required in regulation and what can actually be done technically. And the third question, going back from the technical world into the legal or normative world, we developed these concepts like differential privacy and secure multi-party computation, and we use words like privacy, but do these really match the notion of privacy that comes not from the technical world, but from philosophy, political science, and law? And do we have a way to map between the things? And we don't really have that, and we lack paradigms for mapping between normative concept and technical concepts. And these are part of these are questions underlying this big research question that I'm gonna just talk about a few components of today. So when I started working with lawyers about almost 10 years ago, I hoped for something like this. Now you will see it crossed out. That will be able to take what is written in law and translate it into some mathematical definition, like what we have on the right. But I don't believe this is doable, and I don't believe anymore that this is right for various reasons. And hence, what we'll do is something different. I'll present some elements of this approach to bridging between the legal and computer science privacy formulations. And I will try to convince you that this is beneficial by showing you some examples where we apply these elements. Okay. So coming to this from a computer science point of view, privacy regulations have tons of components. These are complex texts and not really for me to read and understand large parts of this text. But they have administrative requirements and enforcement mechanisms and exceptions and whatnot. And I want to focus here on the restrictions on the set of computations, mechanisms, algorithms that are considered to preserve privacy. So with this view, I'm going to draw this Venn diagram where the yellow area here represents the set of mechanisms. And with this view, the regulation should separate mechanisms into two sets, the good privacy mechanisms and the bad privacy mechanisms. But this is not what happens in reality. The definitions of the legal standards are not formal from a technical point of view, and what we are likely to see is more like a blurry picture like this. Maybe there are some privacy mechanisms that are clearly good or those that are clearly bad, but we're not going to see a crisp line between these two sets, but something more like a blurry line. Okay, and with this view, the law is open to interpretations, and one lawyer or scholar can come up and say, oh, this beast represents the set of good privacy mechanisms. This is my interpretation of the legal requirement. And then somebody else will come and say, oh, it's this beast that represents the set of good privacy mechanisms. And they don't, there would be mechanisms on which they will agree, but generally there's no agreement. And this creates a lot of problem for us coming from the technology point of view, because we want to design systems, and for that we need to have some requirements, some clear requirements that we will try to satisfy in order to protect privacy. But if the law doesn't give us these clear requirements, it seems that we're in trouble. So what can we do? So back to this picture, I want to suggest an idea. There is a lot of blurriness here, that's right. But what happens if we consider all reasonable, possible interpretations of the legal standard? Okay, so with the two interpretations that I just presented, it will look like this. And you see, hopefully there's gonna be kind of an intersection area, an area of agreement, and we'll try in this presentation to establish some properties of this area of agreement. And with this area of agreement, maybe we can identify a set a large set of mechanisms that are good under any reasonable interpretation. And similarly, maybe we can identify those mechanisms that are bad under any reasonable interpretation. And I want to say that this is useful and valuable from a few points of view. First, this gives us some certainty. Like we feel as technologists that with the law, we have a lot of uncertainty that we need to deal with. And if we shoot for technology that is here in this area, okay, then we will get high certainty that our systems satisfy the legal standard. It may be much harder to do that, but it can also be like a good incentive for us to work on better and better technology. Okay, so maybe this is a shout out, the only one in this presentation, to technologists. Try to create systems that are good under any reasonable interpretation of the legal standard. Another thing is that you can see the intersection between the two interpretations is quite a complex shape. And probably if we try to trace it accurately, this is going to be an impossible task. And even if we manage to do it, it will create a very, very strange looking shape that is going to be hard to work with mathematically. We like working with mathematical definitions that are crisp and short and understandable. But by looking at a set in the intersection, we may actually try and find a definition that is convenient to work with. So that could be another benefit for this mental exercise. And the last thing I'm going to say about this picture, the way it is that over time, hopefully our understanding will help us to improve the picture and also interaction with the regulators. And hopefully this gray area between the good and the bad will shrink as we get better and better understanding. So I want to go now to this map and to put some simple mechanisms on the map. Okay. The first mechanism I'm gonna consider is what we call the empty release mechanism, or the zero mechanism. And it's a mechanism that takes the personal data. So this is information that is collected about individuals, and often under the regulation, under privacy regulation. So there are restrictions in making it or its derivatives public. And so we could look at a mechanism that takes this data, shreds it, and burns the shreds, and outputs nothing. I call this the empty release mechanism. And it's just one implementation of the empty release mechanism, so you don't have to use a shredder or fire. But while this is not necessarily a good use of the taxpayer money, because we do collect information for a reason, to use it, I want to say that it always protects privacy. So that part of the regulation which defines which mechanisms, algorithms, computations, the word you like, is a good, protects privacy well. This definitely protects privacy well because we release no information that is derived from sensitive information here. Okay. And this is actually a family of mechanisms, all mechanisms that ignore their input data and output something that is independent of their input data. So back to the map, we put all these mechanisms here in the good area, and we actually formulate a principle of, or a property that we wish regulators to obey. We call it at least the empty release, or alter, and it says that any privacy regulation should deem the empty release mechanisms, this family of mechanisms, as providing privacy. Okay, there may be other reasons for this. There may be reasons for disliking these mechanisms. As I said, it's not necessarily a good use of taxpayer money, but the privacy, when we ask whether they provide privacy or not, the answer should be clear. And kind of the opposite of the empty release mechanisms are the identity mechanisms. These are the mechanisms that take personal data, copy input to output, and release the personal data. So here we take the sensitive private information and publish it, make it public. This is certainly not good. It never protects privacy. And this again is a family of mechanisms, any mechanism whose output can be post-processed, so it can be processed to result in the identity is part of this family, and this is what we call in the privacy literature reconstruction attack. Okay, so going back to the map, all these identity mechanisms are clearly not privacy preserving. They should be so under any reasonable interpretation of the regulation, and we can formulate this second principle or property that we call identity. Any privacy regulation should deem identity mechanisms as not providing privacy. And let me introduce one more property that we call not just the entry release. As I said, we collect data for use. We wouldn't spend energy and money and time in collecting data unless we have use for it. So I'm adding here another condition or property, which we call not just the entry release. Regulation should also deem some non-empty release mechanisms as providing privacy. Otherwise, we can never process sensitive information and make the results public. Now you could say, this is idiotic, it's very trivial, is this useful at all? And I'm gonna split my answer into several parts. One is, yes, these are very simple principles and properties. And in a paper by Altman and other friends, we published a couple of years ago a list of 6 general principles for privacy regulation, process protection, inclusion-based protection, and so on. And in a newer work that we made public this year, we, under each of these principles, we articulated properties. So you've already seen these 3 first ones that are on this slide: alter, at least the entry release, not just the entry release, and identity. There's a host of principles and properties here. This is not a complete list, and this is a work in progress that I suspect will be in progress for a long time. But it's a richer picture than than just the 3 simple principles that I presented. Okay, and the second part of the my answer is going to be that yes, these are very simple. And you may think idiotic, but they are already useful for analyzing a major regulation. And to get into this part, I'm going to talk about this concept of data anonymization. It's a concept that appears in many privacy and data protection laws and regulations around the globe, in the US, in Europe, and other places. And these conceive of some magical process that is called anonymization or the identification. It has several other names. And this magical process takes regulated data and transforms it into unregulated data. Okay, so it takes data about individuals, which is sensitive, it needs protection, and transforms it into data which is not like that, and hence not under the regulation. For instance, the HIPAA, the Health Insurance Portability and Accountability Act, has a privacy rule, and it governs the use of protected health information. This is like the regulated data here, like information about individuals, but it does not govern the use of health information that does not identify an individual and with respect to which there is no reasonable basis to believe that the information can be used to identify an individual. Okay, so this is one place where this notion of anonymization exists. Another place is the GDPR. It governs the processing of personal data, but do not personal data rendered anonymous in such a manner that the data subject is not or no longer identifiable. And another occurrence is in the California Privacy Rights Act. It governs the use of personal information, but not consumer information that is de-identified, which means information that cannot reasonably be used to infer information about or otherwise be linked to a particular consumer. So it's really a concept that appears in many regulations, but then you can ask, what do they actually mean when they say anonymization? And unfortunately, in many regulations, it's left undefined. In some other regulations, it is defined through a mechanism that says if you redact this information, then you've anonymized the data. But unfortunately, we have more than 2 decades now of research works showing that this does not really help protect privacy in a meaningful way. And probably the most well-developed treatment of this concept comes from guidance that is available in opinions of the EU's Article 29 Data Protection Working Party. Some of this guidance this guidance predates the GDPR, but and this body doesn't exist anymore. It has changed into the EDPB, the European Data Protection Board, and the EDPB has adopted many of the guidance and opinions of the earlier Article 29 Data Protection Working Party. And in a document from 2014, they break down anonymization into protection from 3 general types of attacks on unregulated data, which they call linkability, singling out, and inference. So with this opinion, if the anonymization mechanism, if that anonymizer protects against linkability, protects against singling out, and against inference, then it succeeded in anonymizing or de-identifying the data. And I want to say that I'm going to give some critique about this opinion, but it really is a very meaningful and important step that this team of experts tried and to a large extent did map the way towards defining what anonymization means, especially that this is left undefined or really badly defined in many other regulations. And furthermore, once you try to understand what anonymization is, you can go and examine the available technologies and see whether they provide protection against these 3 kinds of attacks. And this is a table taken from the opinion and where they summarize this. Now, we'll not have time to go into all 3 parts of this. In recent work, we with Aloni, Cohen, and Micah Altman, we looked at the opinion plus common understandings of these concepts and try to see whether they satisfy these 3 plus principles, actually more than 3 properties that we have that I mentioned before. In this presentation, I will focus on singling out. And this is based on work with Aloni, Cohen, and Micah, Altman, and Alex Wood. And let's see what singling out means. So in Article 1 of the GDPR, they say the regulation lays down rules relating to the protection of natural persons with regard to the processing of personal data. Then in Article 4, they clarify that personal data means any information relating to an identified or identifiable natural person. And then this sentence that at first sight, second also, looks like kind of a circular definition where they say an identifiable natural person is one who can be identified directly or indirectly. And then in recital 26 of the GDPR, there's a little more information. They say that to determine whether a natural person is identifiable, account should be taken of all the means reasonably likely to be used, such as singling out. This is the only account that is actually mentioned in the recital to identify the natural person directly or indirectly. But what we learn is that for the GDPR, if you can single out in the data, then the data is identifiable and hence it still is personal data. Okay, and back to our chart, mechanisms demonstrated to allow singling out are not good privacy mechanisms. They cannot be used in order to, they're insufficient for releasing data in the public. But still, you could ask what singling out means, and the working party guidance understands singling out as the ability to isolate in the data. Okay, I use the term isolation to mean that we identify a combination of attributes that distinguishes an individual from all other individuals in the data. Okay, for instance, if this is our data, okay, so this is information about movie watching and rating them of 3, let's say, Netflix users. Okay, in this data, you can isolate by saying the user that watched the movie The Sting, because there's only one record of a user that did that, or the user that watched the movie Milan between February 19th and March 10th, or the user that doesn't satisfy these two conditions. Okay, the user that did not watch The Sting nor did I watch Mulan between February 19th and March 10th. So these are 3 ways of isolating in these simple data sets. So it seems out that we can use this definition of isolation and in order to understand the concept of singling out. And this was a starting point for work I did with Aloni Cohen a few years ago. And let's see what we found. So here's a simple model in which we will ask the question whether isolation really should be understood as the meaning of singling out. So let's assume there is an underlying distribution, and our data set is a chosen sampled IID from this distribution. It contains n records. And then we push that data through a mechanism that is supposed to anonymize it. It outputs a data release. And an adversary, a singling out adversary, sees the data release and outputs a description, a predicate, on potential records of the dataset X. For instance, the person with blue eyes who is also tall. And the goal of this adversary is to output a predicate that matches exactly one row in the dataset X. So here's our definitional attempt. M, this anonymization mechanism, is secure against singling out if no adversary can isolate a row except with very small probability, and the probability is taken over all the randomness in this process. So let's examine this with the empty release. So you see here, I'm not giving the, although there is an underlying data set, sorry, I'm not giving the adversary any information about the data set, except for the adversary may know which distribution it is sampled from, okay? And let's, for example, think that the dataset is a dataset of 365 random birth dates. Okay. Now, the adversary just picks an arbitrary birth date and outputs as the description. Let's say born on October 23rd. A simple calculation shows that this isolates with quite a high probability, 37%. This is roughly 1 over E. So even though the singling out adversary did not get any information about the dataset, except the fact that it knows it's a dataset about birth dates, the adversary manages to isolate with success probability that is more than 1/3. Okay. This is definitely a problem because we said that we want the adversary to only have a negligible probability of success. But if even for the empty release, the adversary manages like a third of the time, that's really strange. That really is a problem. Okay, and actually this result can be generalized. I'm not going to get into the details here, but using hashing, if the dataset is sampled from a distribution would moderate mean entropy, then the same calculation holds, and the adversary can isolate with high probability, about 37%. And this violates our simple or idiotic principle that we called alter, because we definitely want that the empty release mechanism would be considered as privacy preserving, as anonymizing. Okay, so that's a problem. Now, further work, we looked at linkability and inference, and each of them does not satisfy and the common interpretations of this concept. And we found that each of them has issues with some of these simple properties and principles and properties. Okay, so what do we do then? So I think by now we saw that these simple properties can be used as a way to analyze current regulation and find weaknesses. And hopefully this is a starting point for improving the regulation. I want to say that we as computer scientists can do a little more. We can now start to ask, can we fix the isolation criteria? Can we do something better than that? And in a work with Aloni Cohen, we suggested a notion that we call predicate singling out. This is what happens when an attacker manages to isolate much better than with the empty release. Okay, so we take the empty release as a point of comparison, and then we say that the attacker was successful if they can do much better. So let me just give an example. If the attacker can output something like a vegetarian American female theoretical computer scientist that plays the violin, sings, and somewhat fluent in Hebrew, then the chance, like the a priori chance that such a person exists is really tiny. So it's very unlikely that such a person exists. If we manage to isolate, then it means that we actually got significant information from the anonymization mechanism, definitely information that we would not have if we only had access to the empty release. And that would be a significant way to single out. Okay. So in this case, even if the attacker succeeds with relatively low probability, but not tiny, let's say 1%, then this is a significant isolation. The definition immediately satisfies Alter because given the empty release, the attacker cannot do something like that, and can also be shown to satisfy Anger. So there are useful computations. In particular, anything you can do with differential privacy satisfies. If you work with differential privacy, then you get predicate singling out, security against predicate singling out. Okay, so what do we do with this? Let's get back to the assessment of the working party of various technologies and focus on this assessment about k-anonymity or L-diversity for the purpose of this presentation. They are identical, where they ask whether singling out is still a risk, and they answered in the negative. So let's see if we actually agree with that. K-anonymity is a process, is a concept that may be familiar to you. It was suggested by Samarati and Sweeney more than 2 decades ago. And a k-anonymizer is a process that takes data and suppresses information to make every combination of potentially identifying attributes appear at least k times. So if this is our original data, and we think that zip code, age, and sex are potentially identifying. Actually, it was shown in research by Latanya Sweeney that these are identifying for a large portion of the American population. Then we could try to redact information and get the table on the right, where each row, at least on the potential identifying data, appears at least twice. So if I have a neighbor in my zip code 23456, then because I will not be able to tell which row in the data set is theirs, I will not know whether they had a heart disease or a viral disease. So let's ask, does k-anonymity provide security against predicate singling out? Okay. Note here that the real question we're interested in is whether it provides security against singling out, which is the legal requirement. But now we're asking whether it provides security against predicate singling out, which is this definition that I just described to you. And actually, we can prove a theorem that the k-anonymity typically enables predicate singling out. So it does not protect against this threat. And the proof demonstrates that a typical k-anonymizer actually does the hard work for the attacker. And the attacker just needs to complement the output of the k-anonymizer with a trivial attack, like the one we saw with the birth dates, and that concludes the proof there. In follow-up work, Aloni Cohen introduced another family of attacks that is called downcoding attacks, and proved that a large class of k-anonymizer is vulnerable to downcoding attacks. And also, he used LinkedIn to re-identify students in a k-anonymized dataset that was published by edX. So this, both in practice and theoretically, k-anonymity does not provide a protection against predicate singling out. But remember, we don't need to ask whether k-anonymity satisfies predicate singling out. This is just something that Aloni Cohen and myself invented. What is important is to ask whether k-anonymity satisfies the GDPR notion of anonymization. Okay. And so, to answer this question, I want to say that so far we saw 2 parts. Analyzing the legal text, one can get to the conclusion that if it is possible to single out according to the GDPR, then clearly this means failure to anonymize under the GDPR. Okay, so that's just from analyzing the text of the regulation itself. We don't know exactly what it means to satisfy or not to satisfy the GDPR notion of singling out, because we did not really manage to define that. On the computer side, on the technical side of this picture, we, as I said, we can prove that k-anonymity enables predicate singling out, but there is still this rift to pass in order to say something whether k-anonymity satisfies or fails to satisfy, the use of k-anonymity fails to satisfy the anonymization requirement under the GDPR. Okay, this is the last thing we're gonna do. And this demonstrates what I began with. If you remember, I said, let's try to identify these areas of the picture which are really clear, okay? Either like these are the self mechanisms that clearly satisfy all interpretations, or these are the mechanisms that clearly do not satisfy all the interpretations of the regulation. Now we're using this idea. So this is the picture, the simple picture that I had of the model. And I want to recall some assumptions that we made in this model. First, we assume that the data set X is IID data. This is the simplest possible model of data that we need to deal with. But it is conceivable that the regulators wanted also to protect other kinds of data, not only IID data, okay? So this is like if we only require protection when X is IID, this may be too weak for satisfying the legal requirement, okay? Another point is we don't give our adversary any auxiliary information. Now, we know from experience that in many attacks, it was useful to give the adversary auxiliary information, access to other information except for the anonymized data. So again, we're weakening the requirement. We only require here protection against those adversaries that do not bring with them other data into the attack. And lastly, we restricted our attention to predicates of negligible weight, only those where it's a clear, huge improvement over when the adversary experiences a clear, huge improvement over what they could do with the entry release. But again, it's conceivable that the regulators would also be interested in descriptions that don't have negligible weight, that have higher weight. So overall, what we did here is we presented a notion that is more restricted than what the GDPR regulators probably had in mind for singling out. And hence, a failure to protect against predicate singling out likely implies failure to protect against the GDPR notion of singling out, where I only say likely because there's always some level of unpredictability when we speak about the law. We don't know exactly what the courts are going to, take our analysis and so on. But I think from a logical mathematical point of view, we get to a point where the answer is with almost no uncertainty. So now we can complete the picture. K-anonymity enables predicate singling out. And if it enables predicate singling out, then it also enables the GDPR notion of singling out, because predicate singling out is a weaker concept, a more restricted concept. And this implies that it enables, that in general, k-anonymity fails to anonymize under the GDPR. Okay, so we are in disagreement with the conclusions of the 2014 document. So let me summarize, and then we can have some time maybe for questions. I presented elements of a methodology. I started by talking about the gaps between regulatory and technical conceptions of privacy, and that these gaps cause uncertainty from both sides, but I focused mostly on the side of the technologies. And they also create exploitable loopholes, something that I did not discuss today. But in considering that the data ecosystem is very complex with all kinds of players in it, we need also to take care of loopholes that are left by the regulation and can be exploited by players to their benefit and to the disbenefit of individuals' privacy. A major obstacle is a tight mismatch between the legal and technical concepts. The legal concepts are inherently fuzzy. There are good reasons for that. I remember like when I started about 10 years ago to work in this project, I kind of thought that maybe we could get rid of this fuzziness and everything would be right. I don't think so anymore. I think there are good reasons why there is flexibility and fuzziness in the legal concepts. And also practically, if we want to work with the lawyers, we need to respect the values of their field, and this is one important value. On the other hand, our concepts in computer science are mathematically crisply defined. Even when we don't notice that, the program is a well-defined object. Mathematical definition is a well-defined object, and so on. So this is something that needs to be bridged. And I suggested that to achieve certainty, we need to find these safe zones, which are far enough from the area of legal uncertainty, and try to work there. And then I also presented simple principles and properties for privacy regulation. As I said, this is a work in progress. But what we see is that even simple principles and properties reveal weaknesses in the existing regulation and provide some guidance for future regulation. And I hope we'll see some improvement in taking some of these properties into account by regulators. Let me just flash this slide with some work in related directions. It is accumulating slowly, and I think some interesting stuff is happening. And let me get back to this slide and end here. Thank you for your attention.
Thank you, Kobbi. This was wonderful and on a topic very close to my heart. Andrew, please go ahead. I think we have some questions both in the forum and on YouTube for Kobbi and yourself.
Yes, absolutely, and definitely. I feel the same as Tudor. The number of times that I've talked to someone who has asked me, "Well, what does the law say about anonymization or k-anonymity or differential privacy or these types of output protections?" Especially, it is a burning question that is holding back the field. And so this is by far the clearest explanation I've ever seen, and a really, really brilliant talk. I especially like the graphical picture with the different monsters that ultimately became a simple picture of what was definitely good and definitely bad. It's really, really beautiful exposition. So thank you so much for coming. I guess to folks who are watching, we will try to get to all the questions. I don't know that we will be able to as quickly as we can, but of course we will do our very best. So the first one we have here is, how is Predicate singling out weaker than GDPR singling out? They both seem identical to me. If CS concepts are crisply defined, wouldn't GDPR singling out then be weaker? Professor Nissim, over to you.
Yeah, so I think that's exactly the point here, that we don't know how to define exactly what mathematically, and I don't believe there is a mathematical definition of the legal concept of singling out. What we can do is reason about that place where we believe we're far enough from the area of fuzziness. And for predicate singling out, as I mentioned, we had these three design choices where we said we actually are going to make it too weak for a reason, okay? And that was the fact that the underlying data is IAD data, the requirement that the predicate would have a tiny weight, like negligible weight, and so on. And this approach allows us to make to kind of state what I call legal theorems. It sounds like an oxymoron, right? To make statements about how the technology relates to the legal requirement with a high level of certainty. And I think that's an important goal for us as we go forward with implementing technology that consumes a lot of sensitive personal data, and we need to deal with this uncertainty. So what I suggested today is at least a strategy for doing that.
Very good. Next question is maybe a little bit simpler. So is singling out the same as a reconstruction attack? I suppose, what is the degree of equivalence between those two?
So that's a great question, because there is a question of what is a reconstruction attack also. Like reconstruction attacks have been, it's a concept that, Dinur and I introduced in 2003, but this concept has been used kind of in a ad hoc manner mostly. Like people, including us, showed settings where a lot of the data could be reconstructed from what was presumably private output, and we refer to that as reconstruction attack. So, and by the way, we have a recent paper with collaborators trying to capture what reconstruction attack means. And it is a complex. It's a complex concept when you try to at once capture it for all the attacks. But I think with singling out, the reason I would separate it from reconstruction attack is that typically the amount of information that is recovered by the adversary is going to be rather low, okay? And usually we think about reconstruction, maybe not all the time, but usually we think about reconstruction as a situation where the adversary manages to extract a lot of information from the supposedly private release. And this is why I would tend to separate the two concepts. So maybe this is more like on the side of concepts like membership inference than reconstruction.
That's a good analogy. I like that. One question is about your background. Would you characterize yourself as having more of a law background or a computer science background, and which one is best if you want to work in privacy enhancing technologies?
Yeah, I think they're both best. I personally come from a theoretical computer science point of view. I studied cryptography in my PhD, and then I started working on privacy about more than 20 years ago. And I remember like the point where I did this switch, like studying cryptography, I thought kind of that the privacy problem was solved, and then realizing that, oh, it's wide open. There's a lot to be done there and to work on. I think the law side is fascinating because they also have a huge impact on the world, on real life. And in the end, I hope we'll learn how to work together in a meaningful way. There are a lot of initiatives now, including the CSN Law conference, but also others, trying to find ways for the two very different disciplines to work together. So whoever asked the question, I would say go with your heart. Both are really good choices.
That's a great answer. Let's see. I'm trying to skim through because I know we don't have time for even half of them, it seems. Do you have a use case in mind that is close to becoming accepted by the regulators and uses modern pets like differential privacy?
Wow, that's a that's a great question. I'm not aware enough of the work done by regulators. I try working with them, but only to a limited success, I have to say. I think there's a chance, like regulators definitely proved, like in 2014 already, that they know and understand to some extent some of the privacy enhancing technologies and had opinions on them as we saw, about them as we saw. So I hope there's a chance to, forge an understanding that stronger concepts that exist today, when they are useful, when they are usable, like differential privacy. And I'm saying when because this is still like an open problem, to what extent we can use differentially private computations and also get useful information from data. There are some use cases, but still I think it's a small number of growing. But when you can use differential privacy, I think it will be interesting if regulators would accept that it's a strong notion and that's the right thing to do. But yeah, I think time will tell. Sorry that I don't have a more clear answer than this.
It's all good. Well, maybe with 0 minutes left, I'll ask the last and hardest question of all that's been submitted. Picking an epsilon in differential privacy is infamously hard. How do we pick an epsilon in a legal context? And are epsilons equivalent between use cases?
Yeah, okay, I have two answers for this. First, this was not a presentation about differential privacy, so maybe the question is not relevant for the presentation. But more seriously, I think we are, and we still need to go through a process to understand the real-life effect of the protection that we get from differential privacy. And I would say this, we will make mistakes in the process, and that should be acceptable if the process gets to eventually to a better understanding, a better position in the choice of epsilon. Currently, in the early days of differential privacy, I think the real challenges are to implement algorithms that are differentially private. This is far from being trivial, and with epsilon that is not outrageously high. Okay, but we're still far from, in most cases, from implementing these algorithms with the levels of epsilon that we would, at least the theory would support. Okay, epsilon much larger than 1 is not well supported by the theory. But alongside that, I want to say these real-life implementations are extremely important because they may tell us about really what happens, right? Are these computations with large epsilon indeed causing us trouble from privacy point of view? And can we, do we actually with hard work manage to get computations that have small epsilon, let's say less than 1. Both are important questions. So I would say it's a process. We need patience. If we want to have, like in those cases where we feel we absolutely need privacy guarantees that are well-founded, currently differential privacy is the only framework that provides that. So I think it is worth investing in improving our understanding.
Brilliant. Thank you. I think that's probably all we can get to today. And thank you to everyone who submitted questions. Tudor, would you like to close out?
Thank you, Kobbi, for being here with us. This concludes our second episode in a stellar way. Looking forward to see progress on bridging the two worlds, Kobbi. And thank you for being here with us today.
Thank you for hosting me. It's been a pleasure.
Bye-bye.
Goodbye.
Great job.